Lucy v. Zehmer is a case about intentions, how you must intend to fulfill an obligation to be legally bound, how your internal intentions may differ from an outside viewer's perspective of your intentions, and how an intention to joke about selling something may not compel a court to prevent the sale from occurring. We, as humans, love to joke around and be humorous. I struggle to think of someone who has never at least attempted a joke, though some people's attempts at joking end up like me attempting to perform a backflip, flat on its face. Riding beside laughter and comedy on the convoy of ancient human pastimes is alcoholic intoxication. Oftentimes, clownery and drunkenness go together, as you can observe strolling through any college campus past 8 p.m. What one does when joking is usually not considered serious, and their actions do not acquire some sort of obligation. You don't often see comedians being held up as serious thinkers, no matter how much they wish to be considered that, or satirists excoriated for not putting their ideas into practice. Jonathan Swift was not compelled to advocate for or carry out his modest proposal. However, in the world of contracting and contract law, it is very possible for one to have been joking about entering into a contract and end up legally bound to it, depending on the circumstances. The aspects permeating this ramble, intentions, joking, and intoxication, are all present in Lucy v. Zehmer, a staple of contract law classes. Contract law often has a reputation for being boring, formalistic, and confusing. Hopefully, this case makes things a little easier for people to understand aspects of contract formation. A case well known by law students and lawyers, here is the story of the 1954 Supreme Court of Virginia case, Lucy v. Zehmer. The date is Saturday, December 20th, 1952. The location is Dinwiddie County, Virginia. As you can tell by the peculiar yet charming name of this county, named after the Scottish Lieutenant Governor of Virginia in the 1750s, we are in the rural South. Dinwiddie County is around 51 miles southwest of Richmond, the capital of Virginia. We find ourselves fortunate, as there is more information about the events which led to this lawsuit than in our previous case. Not only do we have the information from the opinion, but the Dinwiddie County website has a whole section dedicated to the case, which helpfully includes a reporter's transcript containing much of the evidence from the trial court, along with the high-quality image of the disputed contract. This image is much better than the image provided in my casebook, which looks like somebody sent it through a broken copier 15 times. I also must thank this 2012 article published in the Duke Law Journal entitled When Money Grew on Trees, Lucy v. Zehmer and Contracting in a Boom Market, which not only provides invaluable further background information, but also reveals some thought-provoking dynamics between Zehmer and Lucy, and suggests some possible limitations behind the legal doctrine relied upon in the decision. Many thanks to Barak, Richman, and Dennis Schmelzer for conducting the research and authoring this piece. Anyways, back to Dinwiddie County. Welford Lucy, better known as W.O. Lucy, walks into the Ye Old Virginia Inn, a restaurant/garage/service station/hotel located off U.S. Route 1 in McKinney, Virginia, now with steam heating. Ooh. Mr. Adrian Hardy Zehmer, better known as A.H. Zehmer, is the owner of the establishment. Today, the place is a little worse for wear, but in the 50s it sounds like it was a happening place. Mr. Zehmer testifies that, quote, everybody and his brother came by there to have a drink, since it was the Saturday before Christmas. Mr. Zehmer, age 61, is a member of a prominent family in McKinney. His ancestors came from Philadelphia, where one Captain Charles Zehmer was a merchant who also owned vast amounts of land in Virginia and Maryland. In the grand tradition of wealthy families in the 18th and 19th centuries, his only son then lost this estate in a game of cards. This son then became a local physician in Dinwiddie County and raised 11 children. Over time, the Zehmers established businesses that increased their wealth and influence in the town of McKinney. These include a sawmill providing railroad ties to the Richmond, Petersburg, and Carolina Railroad, which passed through the town, tobacco farming, dairy farming, and the Ye Old Virginia that Mr. Zehmer owns. Mr. Zehmer is an educated businessman, graduating from Hampton-Sydney College in Southern Virginia. However, he is not on very good terms with the rest of McKinney. An interview with a neighbor of Mr. Zehmer reveals that Mr. Zehmer was known for his drinking. Mr. Zehmer was also active in the Virginia Republican Party, and being a Republican in rural Southern Virginia in the era of the Democratic Solid South couldn't have helped his popularity either. Mr. Lucy, aged 42, also comes from a farming family, but his family had less success. The family's tobacco farm went bankrupt during the Depression, and Mr. Lucy moved from his native Brunswick County to neighboring Dinwiddie County to make a living. Eventually, Mr. Lucy became active in lumber and dairy farming. Mr. Lucy was also not especially well liked in McKinney. Residents recall him being shady with his business and eager to make profits off the land of others. When Mr. Lucy arrives, it is around 8:30 in the evening, and Mr. Zehmer is beginning to close the restaurant. The state of inebriation of both Mr. Lucy and Mr. Zehmer is a matter of dispute. Mr. Zehmer says that he himself was, quote, as high as a Georgia pine, which is the phrase every law student remembers from this case. Mr. Zehmer also testifies that Mr. Lucy was drunk as well. This is contradicted by the testimony of the service station operator at the time, Mr. Walter Husky. He states that Mr. Lucy, quote, was normal as far as I could see. He drove up there and then drove away. I didn't see anything wrong with him. Personally, I don't know if being able to drive away from a bar is evidence that someone was not drunk, but what do I know? Mr. Lucy and Mr. Zehmer head into the bar and start talking. Mr. Lucy brings a bottle of liquor to the restaurant, and both start drinking it. The conversation turns to a plot of land totaling around 471 acres, known locally as the Ferguson Place, which is owned by Mr. Zehmer. Mr. Lucy has apparently been adamant about buying this piece of property. According to the decision, he had known about the property for over 10 years and offered $20,000 for the property 7 or 8 years prior. Mr. Zehmer testifies that Mr. Lucy had told him he was interested in the property before, but Mr. Zehmer told Mr. Lucy he was saving it as a wedding present for his son to farm. Mr. Zehmer also claims that he received 25 other offers to buy the property, and he gave a big old no to all of them. From what I could find from the case evidence and property records, the infamous Ferguson Place is somewhere in this area, about 7 miles west of McKinney and the Ye Olde Virginia restaurant in the Darvilles district. Mr. Lucy, in the tradition of all great men who have been drinking, says, quote, I bet you wouldn't take $50,000 for that place. Zehmer says something along the lines of, yes, I would too. You don't have $50,000 to give. The two of them discuss the terms of the agreement for around a half hour, and Mr. Zehmer writes an agreement on the back of a restaurant receipt. This agreement states that, quote, we hereby agree to sell to W.O. Lucy the Ferguson farm complete for $50,000. Title satisfactory to buyer. Mr. Zehmer asks his wife to sign it with him. Mr. and Mrs. Zehmer sign it, and Mr. Zehmer gives it back to Mr. Lucy. Mr. Lucy offers $5 to seal the deal, but Mr. Zehmer rejects it. Mr. Lucy then walks off with the agreement in his pocket. Mrs. Zehmer claims that she did not sign the writing until she was told it was a joke, and that Mr. Zehmer told Mr. Lucy before he left there that there was not a sale. This is corroborated by a waitress who witnessed the transaction. The next day, Mr. Lucy telephones his brother and works out a deal where they will each pay half of the $50,000 for the farm. Mr. Lucy's older brother, John Cleveland Lucy, is the owner and operator of a small sawmill. He also sits on the board of the Farmers and Merchants Bank with the bank's lawyer, Albertus S. Harrison, a friend of John Cleveland. Mr. Harrison is also an elected member of the Virginia State Senate. We will talk more about him later. On January 2nd, 1953, Mr. Lucy writes to Mr. Zehmer and says he is ready to pay for the property. Mr. Zehmer replies that he never agreed or intended to sell. Mr. Lucy and John Cleveland Lucy then sue to obtain specific performance of the sale of the Ferguson Place against Mr. and Mrs. Zehmer. Specific performance is a legal remedy where the court forces someone to perform their obligations under a contract, usually done when simply paying money is not sufficient because of the uniqueness of the thing being contracted for. Essentially, Mr. Lucy is suing to force Mr. and Mrs. Zehmer to hold up their end of the agreement and sell Mr. Lucy the land. It's like when your little brother runs to your parents asking them to make you give him the DS because it's his turn. Mr. Zehmer's defense against enforcing the contract is essentially, "Well, I got drunk and Dinwiddie and I was just joking about the sale." The Zehmers claim that the whole matter was a joke and that there was no binding contract because they did not intend for the note scribbled on the receipt to be a contract. A contract is, quote, "an agreement between parties creating mutual obligations that are enforceable by law." You form contracts every day. Buying a Diet Coke from the grocery store forms a contract, although the laws governing that transaction are different than buying, say, a house. There are certain legal requirements which must be met for an agreement between two people or parties to be considered a contract. If those legal requirements are not met, then a contract was not formed and the court can't compel performance of it. The requirement at issue in this dispute is the requirement of mutual assent, where two parties intend to enter into an agreement and understand that they are creating one. How do courts tell when the parties intended to form a contract? The common law test has evolved over the centuries, and the dominant approach may surprise some. According to Mr. Zehmer's testimony, the whole conversation and the agreement that came from it was, quote, "just a bunch of two doggone drunks bluffing to see who could talk the biggest and say the most. The whole thing was cockeyed. The whole thing was just two drunks up there bluffing and talking. That is the way it was." Since he did not intend to seriously draw up a contract to sell the Ferguson place to Mr. Lucy, the contract is not valid because the two parties did not mutually agree to enter into a contract. This mutual agreement is often referred to as a meeting of the minds between two people bargaining for a contract. At the trial court, the judge had little to go on. There were the arguments from the attorneys and a set of depositions by a small group of witnesses taken in Brunswick and Dinwiddie County. On October 21, 1953, Judge Garland Jefferson Jr. dismissed the action in a 3-sentence order, reasoning that the Lucy brothers, quote, "failed to establish their right to specific performance of the alleged contract." The Lucy brothers submitted a petition to the Virginia Supreme Court, which was then called the Supreme Court of Appeals of Virginia, on January 23, 1954. The petition was submitted and written by the lead lawyer for Mr. Lucy, Albertus Harrison. Just before this, Mr. Harrison was the manager of Democratic Senator Harry Byrd's 1952 re-election campaign. Senator Byrd also ran a political machine which dominated Virginia politics between the 1890s and 1960s. This is not to say that Mr. Zehmer necessarily was targeted by the Virginia government for political or other reasons. His lead attorney, Morton G. Good, was also a Democratic state senator. Apart from Mr. Harrison being a close friend of Mr. Lucy's brother, a possible explanation for why Mr. Lucy employed the services of such a powerful lawyer for this dispute will be discussed later. Just a couple years after this case, Mr. Harrison will find himself on the other side of the judicial bench, with some intervening steps. 3 years after this case is decided, Mr. Harrison will be elected the Attorney General of Virginia. He will then be elected Governor of Virginia in 1962, serving until 1966. Then, on October 23, 1968, Mr. Harrison will become a Justice of the Virginia Supreme Court by a majority vote of both houses of the Virginia General Assembly. He will remain a justice until 1981. As Attorney General of Virginia, Mr. Harrison was responsible for implementing the state's massive resistance strategy in the late 50s, which was designed by Senator Byrd to prevent federally enforced racial integration of Virginia schools. This included closing all public elementary and high schools in the state and using the unused funds to pay tuition for students to attend private schools. On January 19, 1959, the Supreme Court of Virginia found that the statute which allowed the closure of public schools was unconstitutional under the Virginia Constitution, although they also condemned the U.S. Supreme Court's decision in Brown v. Board of Education. One of the judges who voted with the majority on that case was Justice Archibald C. Buchanan, who authored the decision here in Lucy v. Zehmer. Justice Buchanan had been a member of the Virginia Supreme Court since 1946, when he was appointed to fill a retirement vacancy. Previously, he was a lawyer and local judge in his hometown of Tazewell, Virginia. He would remain on the Virginia Supreme Court bench until 1969. Apart from authoring the opinion in Lucy v. Zehmer, Justice Buchanan is known for authoring the opinion in the 1955 case Name v. Name, which upheld Virginia's ban on interracial marriage that would eventually be struck down by the U.S. Supreme Court in 1967's Loving v. Virginia. One interesting fact is that Justice Buchanan and Mr. Zehmer both attended Hampton-Sydney College, presumably at the same time, as Mr. Zehmer is only 1 year younger. Imagine how awkward that must have been. Personally, I'm mortified at the thought that I may have to work on a case with a classmate presiding as the judge. Anyways, on November 22, 1954, Justice Buchanan published his famous decision regarding Mr. Zehmer and Mr. Lucy's dispute. Justice Buchanan, after summarizing the record, begins by critiquing the defense that the contract was invalid because of Mr. Zehmer's intoxication. Mr. Zehmer's assertion that he was high as a Georgia pine is contradicted by his detailed testimony of the events of the conversation, according to Justice Buchanan. He writes that, quote, "The record is convincing that Zehmer was not intoxicated to the extent of being unable to comprehend the nature and consequences of the instrument he executed, and hence that instrument is not to be invalidated on that ground. It was in fact conceded by defendant's counsel in oral argument that under the evidence, Zehmer was not too drunk to make a valid contract." Justice Buchanan further writes that the evidence shows that the circumstances of the contract give the impression that the contract was a serious business transaction and not a joke. Mr. Lucy and Mr. Zehmer dickered over the terms for 40 minutes. Mr. Zehmer revised it when Mr. Lucy said that it should include Mrs. Zehmer as well. The agreement was pretty complete, including the provision about good title, which would assumedly not be talked about if this was just a joke, and Mr. Zehmer allowed the agreement to be taken by Mr. Lucy without asking to take it back. In addition, nothing about the whole thing being a joke was said until after the agreement was signed. All of this indicates to Justice Buchanan that this was, quote, "a serious business transaction rather than a casual jesting matter." Justice Buchanan goes further, holding that even if Mr. Zehmer was joking and did not intend to sell the farm, the contract would still be valid because Mr. Lucy considered it to be serious and binding on Mr. and Mrs. Zehmer and himself. Mr. Lucy's actions after the drunken conversation with Mr. Zehmer is evidence of this belief, including having an attorney examine the title and striking the deal with his brother. The opinion states that an agreement sufficient to create a valid contract, along with the other legal requirements necessary, is found, quote, "if a person's words and acts, judged by a reasonable standard, manifest an intention to agree. The person's actual intentions are not considered." This is what is known as the objective theory of contract formation. Under this theory, contract formation is determined by looking at what a person's outward words or actions would convey to the other party, instead of what they intended in their mind. If a reasonable person in person A's shoes would believe that person B intended to enter into a contract, then a contract was formed, regardless of what person B internally believed. You'll find that much of the legal principles and decisions from courts rest on this reasonable person, and there is much controversy around this standard. Quoting from another Virginia case, Justice Buchanan states that, in contracts, quote, "we must look to the outward expression of a person as manifesting his intention, rather than to his secret and unexpressed intention." This is in contradiction to the older subjective theory of contract formation, which required that person A and person B both intended to contract at the same time. If person A made an offer which could be accepted at any time, and person B accepted later that day, person A could show that there was no contract made if they proved they did not intend to contract when person B accepted. This is commonly referred to as a meeting of the minds. This subjective theory was historically the approach used by courts up until the early 20th century. However, the objective theory is dominant today, although judges still use meeting of the minds erroneously in their decisions. It's been theorized that this test for contracts satisfied a need in an increasingly industrialized market society to have well-defined and stable expectations when engaging in transactions. Business would be much harder to perform amongst people if a contract could be held unenforceable by simply proving you did not intend to contract at that moment the other person accepted, especially when you may be contracting with a business you have never dealt with before and who is not located in your immediate community. Businesses thrive on stability and predictability, and the objective theory of contracts helps provide that in terms of contracting. Justice Buchanan finally orders that Mr. and Mrs. Zehmer must uphold their end of the bargain and sell the Ferguson place to Mr. Lucy. Mr. and Mrs. Zehmer finally transfer possession of the property on December 17, 1954, almost a full 2 years after that fateful night, for a price of $50,000. Curiously, the Lucy brothers were not so keen to hold on to the property they fought so hard for. On January 5, 1955, less than a month after they received the property, the Lucy brothers granted the right to all the merchantable timber on the property to the Lumber Distribution Company of Petersburg, Virginia. The company proceeded to remove all merchantable timber by April of 1956, and the Lucy brothers sold 367.7 acres of the original 471.6 acres to the Continental Timberlands Corporation that same month. The remaining portion of the property was leased to a tenant farmer named W. Franklin Townsend. Townsend was granted the option to buy the leased property for $12,000 as early as 1961. In May of 1962, Townsend informed Mr. Lucy that he intended to buy the property, and Mr. Lucy refused to deliver the title. After filing a complaint in court, Mr. Lucy and Mr. Townsend settled, with Mr. Townsend paying $15,000. This information all comes from the Richman and Schmelzer article. All of this occurred within 8 years of Mr. Lucy acquiring the property. These actions hold the pieces to the reason why Mr. Lucy was so persistent in acquiring the Ferguson place, allegedly. Recall that Mr. Lucy was in the timber industry and was known to be shady when it came to business. It turns out that Mr. Lucy and his brother profited from being middlemen for the burgeoning lumber mills and pulp and paper industry. By the mid-1950s, the South was home to 3/5 of the nation's paper manufacturing capacity, and the demand led to a dramatic rise in the price of timber. Large sawmill operators, hoping to avoid bad relations with local landowners, hired local lumber companies to work as middlemen. The Lucy brothers made a fortune buying undervalued forested properties in remote areas and selling the timber from the properties. Property records show that the Lucy brothers bought and sold land and timber rights for dozens of properties between the 1930s and the 1960s. This situation also implicates Mr. Harrison, as he represented parties in land disputes during this time, including representing lumbermen. In one case, the lumbermen, eager to buy land, negotiated with a person who lived on the land but did not own it to cut timber. Funnily enough, this negotiation also happened while the parties drank a whiskey. Again, all of this can be found in the Richman and Schmelzer article, and there is much more detail provided there, including evidence from the deposition showing Mr. Lucy admitted to driving around Mr. Zehmer's property 3 weeks prior to approaching Mr. Zehmer at the Ye Olde Virginie. The Ferguson place, and the outcome of Lucy v. Zehmer, brought a substantial windfall to Mr. Lucy and his brother. Richman and Schmelzer estimate that by 1962, when Mr. Townsend bought his leased portion of the property, quote, the Lucy brothers had earned at least $142,000 from their $50,000 investment less than a decade earlier. Although this may all be circumstantial evidence, it provides context for the events of December 1952. The hastily created contract made that night may have been the result of one party being more knowledgeable about the value of the property than the other party. Did Mr. Zehmer try to pass off the matter as a joke because he found out how much the land was worth and regretted the transaction? Was Mr. Lucy employing shady tactics to capitalize on a landowner not so in tune with the economic context of the times? Should Justice Buchanan have taken this historical context into account when authoring his opinion? Is it smart to discuss selling something while under the influence? Who knows? Whatever may have truly happened that December night, Mr. Lucy and Mr. Zehmer's dealing shows us that, when contracting, someone may find themselves bound by a contract they did not intend to create. Mr. Zehmer, if truly joking, was an unfortunate victim of a doctrine necessary to provide stability and predictability in the realm of contract law. There are some life lessons to take here. Take care of yourself. Never do business while indulging in libation, and make sure to make your intentions obvious to the other party you are dealing with when coming to an agreement. Until next time, I'm Lex Ursa. Have a good day.